How much time you served already?
Your Honor, I don't know exactly. I was told that the jail will provide that, jail provides that
You
information.
don't have any idea how long you've been in jail?
Going on 5 months and some change.
Okay, well, probably you probably be sent down there and do a few months in a minimum security type place and
Yes,
let
sir.
you stay out of trouble after that, okay?
Yes, sir.
All
Thank
right,
you.
thank you.
All right.
Thank you, Your Honor.
Thank you so much.
If I may be excused and my,
Outstanding money stipulation.
Yes.
Let's try this again.
Brad Stewart.
Mr. Stewart's visiting.
Ryan Hardy.
Good morning, Your Honor.
Morning.
Ryan Hardy with Tim Holt. Your Honor, we just need to get this set back on the trial docket on the 226.
Okay. February 26th.
Yes, Judge, thank you.
All right, thank you.
Thank you, Your Honor, that's all I have.
Thank you. Ms. Rivers.
Yes, Your Honor. I do have several that are out of custody,
All right.
and then they could line up the ones that are in custody. The first one is going to be on page 14, number 35, Joshua Riling, 23 CF 2187. Mr. Riling, if you want to come forward.
Okay.
Your Honor, he was set today for a status to see if he had been accepted into two different programs. He has been rejected from one. One is still pending, so we're going to ask to continue this to the end of February.
February 26th. Okay.
Call today, okay?
Since it's a VOP, would we be able to put it on February 28th?
It's not a VOP.
It's not, it's a new law?
Yes.
26 is good.
Okay, thank you.
Ms. Rivers, who is that?
Joshua Riling, 23 CF 2187. And Your Honor, the next one I have is not on the docket. I did mention it to the clerk and the state. It is Brittany Townsend. Ms. Townsend, if you would approach. Your Honor, she was doing a PTI. She was supposed to be in court at the very beginning of January. There was a miscommunication on the date. She called me the next day. I said, there's a warrant out for your arrest. She has completed all the terms. She did make her way up here. And I've spoken with the state and the clerk. The clerk has confirmed she has completed all the terms and conditions. We are asking if the court would consider withdrawing the capias.
No objection from the state, Your Honor.
Okay, withdraw the capias on it. Thank you.
Thank you. All right. And Your Honor, I believe that's all I have for my out of custody, and the rest are going to be in custody.
Mr. Stewart.
Morning, Your Honor.
Morning.
May it please the court, Your Honor, Brad Stewart on behalf of John Harvard, 22 CF 1810. Judge, we're before the court with regards to Mr. Harvard's technical violation of probation for being out after curfew. Judge, we filed a written denial. It appears as though the state attorney's office has received some additional information. As it relates to this violation of probation, I do need to obtain that. If we could get a different court date to bring Mr. Harvard back so that I can ascertain the merits of the allegations.
You want to go towards the end of February, or you want to have something sooner?
My client is asking for something sooner, Judge.
About February 8th, miscellaneous day, how about that?
Very good.
That's fine.
Is that okay? All right. Is this something like, maybe it'll go away? Is that what we're talking about? All right, never mind, February 8th.
Yeah.
Thank you, Your Honor.
Thank you.
Judge, that's all I have for this morning's docket. I'll be back this afternoon. May I be
Okay, yes. Mr. Williams, you have out of custody?
Judge, I don't actually have anyone out of custody. I've got Kenneth Harrelson is on the docket. Again, I think that's just for a status call. That's the 3850. And I believe Ms. Bosso is handling prosecution of that. Kenneth Harrelson, he was on the docket.
Sorry, I was reading something else.
Kenneth Harrelson, I think we're just here for a status. I think we're just trying to get a date coordinated on it.
Is he here?
No, Judge, he wouldn't be. He's in DOC custody, I believe.
Oh, okay.
Your Honor, this is a 3.0.
Oh, all right. What day you think?
It does appear that we have some dockets on, I think the 8th is already pretty full. Maybe, would it be possible on the 27th of February?
Okay, we'll do it 29th, since that involves testimony. Okay, 29th. Okay, who is that?
That's Jacob Harlan.
Jacob Harlan, come on up. Got him on the docket, Steve? 7. All right, motion hearing. Are you, Mr. Harlan?
Yes, sir.
You don't have an attorney?
No, sir.
How come you don't have an attorney?
I didn't think I needed one to say that.
Okay. You want to make some motion, like, what are you on probation or
Yes, sir.
something? Okay, you want to make a motion?
Yes, sir.
What is it?
Just to get off probation early because I did my 2.5 years on it. And then I have 2 more extra, but already paid off the court and all my other fees. And then I've also done other things while I've been out. I haven't been in trouble and stuff.
Your Honor, I believe I actually replied via email that the state was not objecting. We have checked with the victims about the defendant's request, and they're not objecting to early termination.
Do you owe any type of fees or anything like that? No?
No, sir.
All right, well. Don't come back to court unless you're a lawyer,
Yes, sir.
okay? Stay out of trouble.
Yes, sir.
I'll terminate it.
Thank you.
Thank
If you
you.
wouldn't mind, send me some simple order saying it's terminated, written order.
Yes, Judge, I will.
Okay, thank you.
Thank you, sir.
We will. If he's on
He will?
probation,
Okay.
then we'll send the order.
Okay, thank you. Stay out of trouble now. Now, was it Mr. Williams you had any more out of custody, or you didn't have?
No,
any?
Your Honor, none out of custody. All of mine are in custody.
Where's Mr.,
Gibbs?
Miss Flowers? How about you? Okay. Okay, good.
Carly, good morning. Jennifer Flowers on behalf of Carly Elizabeth Bello and 23 CF 1209. Your Honor, we're working on negotiating with the state, and I've been I just spoke with the state, and I don't think they have an objection to putting this back on the pretrial docket for a plea,
Okay,
226.
you can move it up if you get it resolved sooner. How about that? We'll say February 26th.
We have no objection to that, but the offer would be revoked at that point if she has.
All right. Yeah. All right,
Thank you, Your Honor.
thank you.
Next, I have Tammy Jean Paul. She's present and approaching on 22 CF 2290. We have reached an agreement with the state.
Ms. Paul, would you please, you're Tammy Jean Paul?
Yes,
Would you
sir.
please raise your right hand to be sworn? You swear the testimony you give for us, course the truth, so help you God?
Yes, sir.
Thank you. You want to enter a no contest, okay, this is State of Florida versus Tammy Jean Paul, 23 CF 2517. You want to enter a no contest plea to the charge of possession of paraphernalia, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here
No,
today?
sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 2, withholds adjudication. 270 court costs, $150 cost of defense payable within 90 days. And the state's going to drop the charges on count 1.
That's correct, Your Honor.
Okay. All right. Thank you.
Thank you.
I have in custody, unless,
You want to? We'll go ahead and stay there.
okay. Your Honor, this is Nehemiah Liam Barnett, located on 23 CF 2523, 23 CF 2524, and 23 CF 2661. Your Honor, I filed a motion with the court, motion to reduce bond, that I'm sure the court has reviewed. I set out all of the facts of the cases. The defendant's total bond currently is $95,000, cash or professional. The defendant lives locally in Crestview and has the support of his mother, who's been in close touch with me and has told me she would ensure his appearance in court. Her name is Nicola Barnett. The defendant is employed as a subcontractor for Carpet One. He has 3 minor children for which he provides financially. He's been found indigent, of course, and cannot afford to post such a high monetary bond. So at this time, we're asking the court to reduce his bond to a reasonable.
Can you tell me what his name is? Someone was coughing and I
I'm
couldn't.
sorry.
couldn't-
Yes, Barnett is the last name.
Barnett, okay.
Nehemiah Barnett.
Okay, I got you. Let's see, he's, well, he's got, what does the state say?
Your Honor, the state believes that the bonds are appropriate the way they are, given the fact that he's currently facing several charges, main one being trafficking in fentanyl. We actually have received the FDLE back and confirmed that it was fentanyl. That carries a 7-year minimum mandatory. He scores a minimum of 119 points, which equal to 68 months in DOC. The facts related to the fleeing and eluding are egregious. He endangered several other drivers while law enforcement was chasing him. Additionally, the trafficking amount of fentanyl was found on his person at the time of the arrest. When they were,
Is he looking at 18 different charges?
Your Honor, yes,
I might just leave the bond the way it is.
Yes, Your Honor.
Thank you. That's too many charges. Thank you.
Your Honor, this is Matthew Ferkel in 23 CF 2529. We've reached an agreement with the state for a plea. 6 months. Okay. I've signed, let me get Mr. Ferkel to sign We have previously gone over this plea agreement, and he understands the terms.
Matthew Joseph Ferkel, right?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay.
I may approach with the plea.
You want to enter a no contest plea to the charge of it's battery of a detained person in a facility, jail facility, correct, Ms. Flowers?
Yes, Your Honor.
All right, and this is State of Florida versus Matthew Joseph Ferkel, 2023 CF 2529. And Mr. Ferkel, did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you
Yes,
on your
sir.
case? Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentences you 6 months Okaloosa County Jail concurrent with case number 23 CF 902 with credit for time served, $415 court costs, $100 cost of prosecution, $150 cost of defense, all to collections. And I don't need a score sheet. This is a misdemeanor. Is this? No, this is, no, it's a felony, isn't it? Yeah, okay. Thank you. All right, thank you, sir. Austin Geis, okay.
Yes, Your Honor, this is Austin Gregory Geis, 23 CF 2533, 23 CF 2535. We've reached an agreement with the state.
Mr. Geis, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Thank you.
And he is just going to sign. We've previously gone over the plea, and he indicated he had no questions. Thank you. Let me approach.
Thank you. This is State of Florida versus Austin Gregory Geis, 23 CF 2533 and 23 CF 2535. All right, you want to enter a no contest plea in 23 CF 2533 to the charge of grand theft, as a lesser included offense of robbery without a firearm, correct?
Yes, sir.
And in 23 CF 2535, you want to enter a no contest plea to the false use of an ID which adversely affects another. So both of those are third-degree felonies. The first one is down from a second-degree felony to third degree. So you want to enter a no contest plea to those two charges, correct?
Yes, sir.
Did you read and sign his plea and sentencing agreement form? This form, did you read and sign it?
Yes, sir.
Okay. Do you understand the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it on 23 CF 2533. Your judge guilty, sentenced to 2 years community control, followed by 3 years of standard probation. The court reserves on restitution, 515 court costs, 150 cost of defense, waived cost of supervision. In 23 CF 2535, your judge guilty, sentenced 2 years community control, followed by 3 years standard probation, concurrent with 23 CF 2533, 515 court costs, 150 cost of defense, waive cost of supervision. So it looks like you're getting 2 years community control and 3 years standard probation concurrent. So just stay out of trouble, okay?
Yes, sir.
Okay, thank you.
Thank you.
You
I
have
have
a
it.
score sheet.
Oh, okay.
Your Honor, this is Kevin Lloyd and 23 CF 2590. We have reached an agreement with the state, and Mr. Lloyd and I have previously gone over the plea agreement form. He just needs to sign.
Okay.
May I approach?
You're Kevin Lloyd.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
Thank you. This is State of Florida versus Kevin Joel Lloyd, 23 CF 2590. You want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, and possession of narcotics equipment, a misdemeanor, first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form? You understand the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. In 23 CF 2590, judge guilty, sentenced to 60 days county jail with credit for time served, followed by 24 months drug offender probation, have a substance abuse evaluation, and follow any recommended treatment. 515 court costs, $150 cost of defense, maintaining gainful employment or show 3 applications per week. Court will waive cost of supervision, no alcohol or drugs without a prescription. On count 2, you're judged guilty and sentence you to time served. Okay? Thank you. Elizabeth Shannon.
This is Elizabeth Hope Shannon and 23 CF 2074 and 23 CF 2403. We've reached an agreement with the state, and Ms. Shannon and I have previously gone over the agreement. She just is going to execute her signature. Thank you. May I approach with the plea and score sheet?
You are Elizabeth Hope Shannon.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
All right. You want to, this is State of Florida versus Elizabeth Hope Shannon, 23 CF 2074, 23 CF 2403. You want to enter a no contest plea in 23 CF 2074 to possession of a controlled substance, a third-degree felony, and possession of paraphernalia, first-degree misdemeanor. And in 23 CF 2403, no contest plea to possession of a controlled substance and count 2, possession of paraphernalia, a third-degree felony, and a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir, I'm not.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. In 23 CF 2074, count 1, withhold adjudication, 2 years standard probation, have a substance abuse evaluation and any recommended treatment, have a mental health evaluation and any recommended treatment. Take medications as prescribed, no alcohol or prescription drugs without prescription. have random UAs, 515 court costs, $150 cost of defense, waive cost of supervision. In count 2, withhold adjudication, 1 year standard probation concurrent with count 1. In 23 CF 2403, count 1, withhold adjudication, 2 year standard probation concurrent with 23 CF 2074. Have a substance abuse evaluation and any recommended treatment. Have a mental health evaluation and any recommended treatment. Take medications as prescribed, no alcohol, prescription drugs without prescription. Random UAs. 515 court costs, $150 cost of defense, waive cost of supervisions. All requirements are concurrent. And count 2, withhold adjudication, 1 year standard probation concurrent. So they're all concurrent with each case and each count. I'm not telling them that they're having too good a time. Make me need to put some of them in prison or something.
Your Honor, does the court have any preference on, do you want her to have the drug eval done first or the mental health eval done?
It doesn't matter. Whichever one she can get done first, doesn't matter.
All right, thank you.
Okay, next.
Your Honor, this is Christopher James Stearns and 22 CF 3069. This is a VOP. We've reached an agreement with the state. He's going to admit, and I have the agreement and the score sheet, if I may approach.
Okay. Mr. Christopher Stearns, correct? Would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir.
Okay. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No.
Are you under the influence of any drugs or medication that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. He is adjudicated guilty, sentenced to 90 days Okaloosa County Jail, waived credit prior to December 12th, 2023, and then revoke and the court's going to revoke and terminate probation, $100 cost of prosecution, $150 cost of defense, within 90 days of release, then to collections, and adjudicated guilty. Okay, so you're about out, but okay, thank you.
Thank you. And I believe that's all I have before the court today, if I may be excused.
All right, thank you. I don't think we have any detention hearings today at 12:30. Good. Okay.
Charles Russell, Public Defender's Office, Judge. Page 15 of your docket, number 40, Daniel Kilburn. Case numbers are 17 CF 3565 and 21 CF 452.
Daniel Kilburn.
That's right.
Okay.
Your Honor, the court previously allowed provide to us fairly last minute. We were able to get 3 done in short notice fashion, but the other 3 were unavailable. Those have been reset.
Right, but they weren't provided last minute, Judge.
So
those, they have been set, the remaining ones have been set. Additionally, Your Honor, there was a child hearsay hearing that needs to be set. We still need to provide to the defense the edited version of the CPP that was rather lengthy. I'm suggesting, Your Honor, we do have the 227 and 229 court dates, so still before the next trial cycle. And I would have those edits to also no later than 2 weeks prior to that. That's acceptable.
How about that? So those hearings would be on the 27th and 28th?
27th or 29th, whichever the.
I mean,
the
29th.
court wishes. We have our deadlines on the 28th.
Oh, I got you. So the hearing is on one of those 2 dates.
Yes, so I believe that's what is available, that's why I suggested.
All right. What do you, 29th?
27th, could we, Judge? Do
Okay.
you have any, what do we look like? You want to do it at 2, right?
It would have to be the afternoon, I believe, because Ms. Judge would like to review that.
Okay, 27th.
27th
Yeah.
at 2?
Yeah.
And then the state said that they were going to provide me the edited CPT 2 weeks before?
Yes, sir.
Okay. That'll work, Judge.
Okay, thank you.
Your Honor, the first case would be page 12, number 31 on the docket, George Oppert, 23 CF 1451. Reached agreement in this matter, if I may approach.
Okay. You're George Oppert.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
Okay, thank you. You want to enter a no contest plea to the charge of attempted burglary of an occupied dwelling, a third-degree felony, correct? And this is State of Florida versus George Oppert, 23 CF 1451. Did you read and sign his plea and sentencing agreement form? You gotta say it out loud.
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, sentence you 5 years probation. Complete Phoenix House bars to bed. Cannot leave Phoenix House without permission. No drugs or alcohol without a prescription. Take any prescribed medication. Random UAs. No contact with Molly Cooper. Do not return to 5365 Dora Street, Baker, Florida. Maintain gainful employment after completing Phoenix House. If not gainfully employed, then complete 3 job applications per week. Witnesses can appear via Zoom with a notary for any future VOP hearings for this case. 415 court costs, $100 cost of prosecution, $150 PD fee, waive cost of supervision. And I think that's it, right? Thank you.
You'll have to see them. Your Honor, this is Michael Paul Owen. He is before the court on 19 CF 2090. We're here on our motion to set bond.
Okay.
Mr. Owen is before the court on violation of probation. Your Honor, he currently has no bond. He's asking the court for a signature bond or an ROR bond or any low bond that the court sees fit for this case. Mr. Owens, prior to the violation of probation being filed, he had filed with this court a motion seeking modification of his probation because of some things that were occurring. And on the date in question where he was given the driving while license suspended charge, he was actually responding to his girlfriend who had a medical emergency. I can actually ask Mr. Owens some questions to give the court some more information on this.
Well, hang on 1 second. So he is he on probation?
Yes, Your Honor.
This a VOP?
Correct, Your Honor.
And so his violation of probation is a new charge of what, driving?
Driving while license suspended.
That's it?
Your Honor. Yes, Your Honor.
Oh,
Well, that's right, there's the additional.
Untruthful reporting on several occasions.
untruthful reporting?
Changing residence without permission.
I never changed residence, Your Honor.
Oh, hang on a second.
Yes, sir, no problem.
Yes, go ahead.
Your Honor, this is his third violation of probation.
The last time we were here on a violation of probation, it was a plea to the bench, despite him scoring 20-something months in prison. Your Honor gave him a reinstatement of probation of 5 years with a suspended sentence over the state's objection. So this is the third violation of probation with a new law offense of driving while license suspended and unlawful or being untruthful to his probation officer. At the last VOP hearing where the court downward departed and reinstated, he was carrying a 10-inch blade machete at Fort Pickens, acting erratically.
Oh,
while he
this-
was on
that case.
probation for possession of a firearm by a convicted felon. Also, he's on probation for burglary of an unoccupied conveyance, 2 counts of that, and petty theft. So he's not entitled to a bond. This is his third time in. He was given a chance by the court last time, and now he's back very recently. It hasn't been too long ago that he was sentenced by Your Honor. So the state's asking
What do you say?
And Your Honor, as for the changing the residence, he maintains he did not change residence. He did secure a residence for his girlfriend and her child, but he did not live there. He maintained his status.
I worked for a apartment complex, as you well know from the last time of me being in here.
Raise your right hand to be sworn. You swear the testimony you give for is court's truth, so help you God.
Yes, sir.
I don't so well know anything about any.
Okay, I apologize, Your Honor. Last time I was here, I turned in documentation stating that I worked for an apartment complex. My boss had me living in apartment complex in units that I was remodeling at the time where my probation officer showed up to see me. I did secure a residence for my girlfriend and her grandchild so that she was closer to her daughter at the time so that somebody could care for her when I was at work and unable to do so. The paperwork that I submitted to the courts before the violation ever came through was stating just that was the modification I was seeking, is that I could move to that residence that I secured for them so that I could be there to help out. And that's the whole reason I'm asking for a bond today. She's had 3 procedures since I've been incarcerated this time. She has another procedure today, hence the reason she's not here today, and she's got 2 more procedures coming up in February. So that's the only reason I'm even seeking a bond, Your Honor. Or I'll be honest, I'd just sit and wait this out till we could finish it. The only reason I'm seeking is I'd like to be able to go home and help out where I was already doing so.
Your Honor, the probation officer attached a signed lease agreement the defendant signed. And once he was made aware that the probation officer had discovered he was living in another state, that's when he sought modification to move to Bruton, Alabama. But he had been living there according to the lease that was signed since October.
I believe the state is misinformed because if she looks at the dates, the date that I turned in the requests to the courts was 3.5, maybe a whole month before the violation even came into play. Did I sign a lease? I just admitted to that. I did sign a lease for her to have a place to lay. That I did do. Was I living there? No. And I have proof that I wasn't living there because my probation officer came and seen me where I was in the apartment complexes. And my boss will be more than happy to admit that I was there.
His bond is what? No bond?
Yes,
There's
Your
no
Honor.
bond right now, Your Honor. And
Who signed that bond? Got a first appearance, judge? ID.
Looks like Judge Schlechter. Your Honor, he does score 29 months DOC currently. His criminal history includes assault, felony battery.
I know all that.
I'm sorry.
I know all that.
Your Honor, could I say one more thing?
What do you want to say?
The last time I was in here, you told me to get out and do the right thing. And I promised you that I would. Had I known my license was suspended, I'd have never been behind the wheel. That I will say.
See, well, what I'm going to do is, $5,000 signature bond. If you're running out of lives, Mr. Owens. Thank you.
Thank you, Your Honor.
Your Honor, if you can just make Mr. Owens aware that he is still on supervision, and he still needs to report and comply with all the terms and conditions.
Yes.
So, yeah, I just spoke to the driver, driving on suspended, I was arrested on the 4th, and I had that hearing on the 11th with my probation officer knew about it. So I missed that hearing, so I'm assuming, I don't know if it's the case or not, I'm assuming that County probably has
I don't have any jurisdiction
I
over
know
it.
you don't, sir, but what I'm saying is.
He's just
there's a
making the court
possibility-
aware.
I'm making the courts aware that there's a possibility, I don't know how it works, Your Honor. I've never been in this situation.
All right, well,
I just wanted to make probation aware.
you're still on probation, and you need to obey the terms of your
I just
probation.
wanted to make them aware that if that's the case, I'm still gonna be incarcerated in Escambia, so there's no way for me to report.
I got you.
Yes,
Thank you.
yes, sir.
Your Honor, before the court is Timothy Parrish, 16 CF 958, 23 CF 2725. We're going to request, we're going to enter denials. I think we already have, but we're going to request a continuance in this matter. We were waiting for the state to make an offer. I got an offer this morning. I am showing it to them now. We're going to request a continuance.
Want to come back on February 8th?
Your Honor, if we could make it later in February.
What about 27th?
Yes, Your Honor.
27th, how about that?
For the suspended sentence.
Okay.
It's her offer. And how do you say your last name? Poirier, okay. Your Honor, this is Carmen Poirier. She's before the court on 16 CF 2492 and 17 CF 935. We were waiting for an offer from the state. I did just receive that offer. We're going to request, put this on February 8th.
Did you get that one for us?
Yep, yep.
Okay,
90
February
days,
8th, thank
Okaloosa
you.
County Jail. The day you got arrested.
Okay, so that's what I'm saying. Okay,
So I'll come out there and we'll go over it.
okay,
Okay?
okay, thank you.
Uh-huh. Your Honor, this is Milan Sears on 20 CF 489. He's before the court on violation of probation. We're going to enter a denial. Your Honor, if we could have it for February 8th.
Thank you, yes.
I'm sorry? Well, I'll come out there and you can sign it on the 8th, because you still have the time. Your Honor, the next case is Damian Tapper, 23 CF 2548. He is here before the court on a motion for bond reduction. Your Honor, he is unable to post any type of bond. He is charged with battery on a corrections officer for spitting. Most of the time when we do bond hearings, we talk about their ability to post a bond, their ties to the community, things such as that. Mr. Tapper has lived here for a while. However, his family members are outside of the community, and that is one of the reasons he's been unable to post the monetary bond, because a bondsman will not have someone on it who is not from the area. And in this particular case, I feel like it'd be appropriate if the court would consider watching the video as to why he is charged with battery on this case.
We're not scheduled for trial.
Right.
Today.
And, Your Honor, in lieu thereof, I would like to just bring out a few things about this particular charge.
Why was he in jail?
He was in jail on a misdemeanor trespass, and an issue arose over, they were insisting that he put on orange, which is for felony, and he said, no, I'm here for misdemeanor. He was in the holding cell refusing to put on the orange jumpsuit. They told him to put on the orange jumpsuit. He, in fact, was putting on, in the video that the state produced, he was, in fact, putting on the orange jumpsuit, had it 3/4 of the way on when an officer held up a can of spray.
Hang on one second. What's his current bond?
Was it five?
10,000.
10,000. 10,000.
They won't let me even for $1 out without a
$10,000 cash professional.
What does the state say?
Your Honor, his out-of-state NCIC, the criminal history shows that currently he has a warrant out of Marietta, Georgia. I've spoken with the jail. It's my understanding they're waiting to hear back, but they're probably going to put a hold on him. He also has a recent failure to appear conviction for out of Cobb County, Georgia, just recently as July of last year. I think the state
I handled that one.
$10,000 reasonable. He's a flight risk in this case. He has criminal history out of Georgia, California, and now Florida. No ties to the community, and he has looks like he has 2 trespass cases of.
That was when I was in jail.
He's got a prior battery.
Well, that flight risk, he's got those, he's got a failure to appear out of another state or something, so.
His NCIC shows he has a warrant as of October 31st, 2023, out of Marietta, Georgia.
All right, I'm gonna just leave the bond the way it is.
Could you just take a look at this, how I was just completely battered and maced?
I'm not making a decision on that, I'm making a decision on your failure to appear out of another state.
Well, I've been here for a long time, but I don't have a failure to appear. I have a waiting, I was released on, you need to see your probation officer, and I came down here to Florida and was planning to get it transferred, and then I got picked up here, but I appeared for that last case. I don't have a current failure to appear there, but
All right,
I had
thank
a
you.
failure to appear, but I took care of it when I got out. It was sitting at report to probation.
Well, the state will
within 3
check, their
months.
state's checking on it to see if there's a hold, so, thank you.
So it would just be the regular bond if I could get out.
But they're saying that Georgia has a hold on you. Your Honor, this is Jeffrey Wagner. He's before the court on violation of probation 20 CF 380. We're going to enter a denial at this time. He has new laws pending. We would request to run all of them together.
Okay, what date you want?
Do you want to make it for February 26th?
Right now, the arraignment is set for 422.
So, for
229, I guess.
229, Your Honor. That'd be fine.
Okay, thank you, sir.
Thank you, sir. Thank you, Mr.
Your Honor, this is Ronald Ward. He's before the court on 22 CF 3142 for violation of probation. We're going to enter a denial at this time. He has new law charges. They're already set, I think, for 226. It may be later. At 227.
Yeah, February 27th.
Well, if we could continue this to the February 27th court date then.
Okay, February 27th. Is that okay, Ms. Glisson?
Yes, Your Honor, that's fine.
Okay. Thank you. All right, Christopher Hargrove.
Judge, we've got a negotiated plea in this case.
Mr. Hargrove, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
Thank you. This is State of Florida versus Christopher Hargrove, 23 CF 2655. You want to admit that you violated probation?
Yes, sir.
Did you read and sign his plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir. Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Court's going to revoke and terminate probation. Sentence you to 4 months county jail with credit for time served. $100 cost of prosecution, $50 PD app fee, $100 PD fee. Reduce outstanding monetary amounts to collections and adjudicated guilty.
Yes, sir.
Thank you.
Thank you.
Thank you, sir.
Hang on one second. Hang on one second. Oh, this is also 23 CF 2656 and 23 CF 2655. The court sentences them the same on each case, concurrent. Okay?
Thank you, Judge.
Okay. Kenneth Harrison.
Judge, Mr. Harrison has got substantive new law violations already in the docket for February 26. I'm going to ask that this track with those.
That's fine, Judge.
Okay, February 26th. Thank you.
Thank you, Judge.
Christian Hart, okay?
All right, Judge, the state's, and I've gone back and forth on an offer. We need to look at whether or not he can get into a treatment regimen. I don't have an answer on that as yet, so we need to pass him out. I am going to be filing a motion for bond reduction in this case, and on that, perhaps we can bring him in as early as 2/8.
Okay, we'll bring him back on February 8th.
Thank you, Judge.
How about it? Thank you.
Mr. Williams, just to be clear, though, if he gets a bond, then the offer is not
Well, if
in
if
place
he gets a
anymore.
bond, it would likely involve a drug patch, so we would know he was staying clean.
Well, that's not the offer. The offer is bars to bed, inpatient, so,
All right, I'll go over that with him again.
thank you.
All right, David Johnson.
Yes, sir.
Mr. Johnson. All right. Judge, Mr. Johnson has an offer either for being revoked in term and then put on a new term of 1 year community control or 6 months county jail. He's had an opportunity to check with his employer to see if his job would still be open then, and the employer indicates that he needs to take the community control. So that's what he's going to do.
Help me, yes, sir.
Okay, so if I can get your signature there. He was given a copy of the plea agreement last night, and I went over it with him. Okay, do you understand everything in the agreement?
Yes, sir, I
And you need me to answer any further questions for you?
No, sir.
Okay.
All right, this is 23 CF 168, State versus David Johnson. Mr. Johnson, would you please raise your right hand to be sworn? You swear the testimony you give before this course is true, so help you God.
Yes, sir.
Thank you.
outlined.
Mr. Johnson, you want to admit that you violated probation? You want to admit that you violated probation?
Yes, sir, I did.
Okay, you don't have to put up your hand now. Did you read and sign his plea and sentencing agreement form? Did you read and sign this
Yes.
plea and sentencing
Yes,
form? Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it, revoke and terminate, sentence you to a new term of 1 year community control, same terms and conditions, $100 cost of prosecution, $50 PD app fee, if not already paid, and $100 PD fee, and adjudicated guilty.
Thank you,
Yes,
Judge.
sir.
Thank you.
All right, good luck to you, sir.
Thanks.
Mr. Langley.
All right, Troy Langley.
Yes, sir.
Judge, Mr. Langley, I went out to see him last night. He was not brought down for some reason. I did speak with him in the conference room here at the courthouse this morning. What we're going to have to do is just enter a denial for him at this time. He has asked me to bring him in for a bond hearing on it. If the court wants to set him as early as 2/8, I can get that drafted up and
Okay,
we can put him on the docket
Sure.
for that.
all right. February 8th, thank you.
All right, sir. Okay.
Thank you so much, Mr. Williams.
No problem, no problem.
Your Honor, on Mr. Johnson that we just had, you said same terms and conditions. I don't know if his previous cost of supervision was waived, but if it's not, we request it be waived.
All right, I'll waive it. Okay.
Judge, this is Michael Livingston. The court set it for a bond hearing today. Mr. Livingston had brought a Nelson inquiry, and some bond was discussed on it. I filed a bond motion for him, and if the court's ready to hear that, I've got a few additional questions to ask him.
All right, Mr. Livingston, would you please raise your right hand and be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
Okay, thank you.
All right, please state your name and for the record.
My name is Michael Livingston.
And Mr. Livingston, can you make, currently I believe you have a no bond, is that correct?
No, sir. I have a $25,000.
$25,000?
And a $5,000.
Are you able to make that bond?
No, sir.
Okay, that's right. You're not here on VOP. You're here just on new law violation.
Yes, sir.
All right, how much bond can you make?
At max, maybe 1,000 professional, sir.
Okay. Now, the allegations in this case involve allegations of battery on your mother.
Yeah,
Okay. Did I explain to you that typically on a domestic case, there'll be a GPS monitor and an exclusion zone?
Yeah, absolutely.
Would you comply with that?
I'm absolutely more than willing to do so, sir.
All right, Judge, what I'm going to ask for is, since it's a battery, well, they've got burglary of a dwelling with assault or battery. We're disputing the burglary part of that. And then a resisting without. The resisting without involves him just running away. I'm going to ask for a $5,000 bond, but suggest that the court, if the court needs, has concerns about the safety of the victim, safety of the community, that the court give him a GPS on it, with an active one with, say, a 2,000-foot exclusion zone. I've explained to him how that works and that he would then have to stay outside the shaded area on the map that he's given when they attach the GPS unit. He's willing to comply with that. Currently, he's in the ECLC portion dorm in the jail, so he is dealing with some issues. We're also looking into some medical type information on him, and I'd ask that he continue to cooperate with us with regard to
Is he
that.
scoring type of prison time?
Yes, Your Honor, he scores 47.25 months DOC. He's currently charged with a PBL in count one. That bond right now is $25,000. Count 2, the resisting without violence, is 5,000, so he's got 30,000 total. In this, well, his criminal history does include several misdemeanors. He's got felonies of burglary of a conveyance, aggravated assault by threat with a deadly weapon, possession of a controlled substance, grand theft. Again, he's got several misdemeanors. The victim in this case is scared that he will be released. She's scared. It is his aunt, according to the paperwork. He did enter without permission and punched the victim several times, causing her to have a black eye, bruises, and knot on her spine.
Judge, testimony on the video, the officer's body cam video, when he met with her companion and then met with her. The companion described one incident of seeing him swing and then hearing a smack. There was not a lot of detail gone into with the alleged victim, but the alleged victim indicated that she did not want to prosecute on it. He is charged, even if he were just charged with, say, an aggravated battery or something like that, a first offender would score state prison. It's a level 8 offense, but my understanding is that this is a family home. We do have them all scheduled for depositions. I believe it's towards the end of the month.
Is the victim said she don't want to prosecute?
Not to the state attorney's office, Your Honor. That's the first I'm hearing of it.
If you would look at the videos in the
We've
case.
had contact with her since then, and she does wish to prosecute.
It's battery-3, I believe.
Battery-3, what is that telling me?
That's the file name. The body cam videos have different file names. That's the file name of the video that that statement's made on. Do you want us to reset it and give the state an opportunity to try to bring her in? I've got her, like I said, I've got her scheduled for depositions.
And Judge, we've spoken to her as of November 1st, was after the incident. I can tell you the victim advocate has spoken with her, and the victim is afraid that he will get out. She has to wear a back brace for her spine injuries. Her nerve is messed up.
I tell you what, let's bring him back February 8th and have a chance to talk to the victim, because the last time he talked to her was November.
Yes, Your Honor. That's the
Well,
last
let's
noted.
bring him back February 8th and see what she says. Talk to her, go ahead and talk to her and see what she has to say. Okay, thank you.
Thank you, Judge.
Thank you, Your Honor.
All right.
Judge, we're not yet in a position to resolve Ms. Medina's case. She's asked us to check into a placement for her in a rehabilitation program. I'm going to need to, I just heard back from my investigator, I'm going to need to talk with her further about that particular program. The state has made an offer. It's an offer for county jail. She doesn't want to accept that. She wants to try to get out. So
you want to bring her back when, February 27th or something?
yes, sir, that's what I'm going to suggest. If I can get it resolved and get her in earlier, I'll do so.
Okay, February 27th, thank you.
Thank you, sir.
What about Mr., is that it for you, Mr. Williams? Mr. Gibbs?
Yes, Your Honor. I'll start with out of custody, if I may.
You heard anything from Mr. Nopes on, oh, that's this afternoon. Okay,
Good morning, Judge.
morning.
Judge, out of custody first on this morning's docket, I believe I have Ms. Amber Foreman. Judge, Ms. Foreman is present and approaching. Your Honor, Ms. Foreman is on today's docket as a control date or a status call. If the court recalls previously, she was here, she was given until today to pay the court costs associated to her case for the case to be dismissed. She indicates that she had run into some issues with the clerk trying to make sure all the paperwork was going through, and so she's tried to pay it. I believe she's paid about $150 towards it so far. We're essentially asking for an extension on that to give her time to pay so that the case can be dismissed.
No objection, Your Honor.
All right, how much time does she want?
How much time do you think you'll need to pay the rest of it? 90 days?
Yeah.
We'd ask for 90 days, Judge.
I will not agree to that,
How much she
Your
owe?
Honor.
How much time would the state be?
I was hoping the 8th, February
February
8th,
8th?
or there is a plea to a misdemeanor.
Okay.
Withhold, and just the court cost that she can pay within 90 days.
So, I may have misspoke earlier, Judge. The issue that she ran into is she tried to pay, but the clerk wouldn't let her.
That's correct, Your Honor. So the first time I went, can I speak?
Yes.
Okay. So the first time I went down there, I spoke with David, and he said that the information, because I went down there as soon as we got done, he said that it wasn't in there, so I couldn't do anything then. Then I called and I spoke with Miss Leah, and she told me that it was in. Then I came in, she said the court date wasn't until January, so that she couldn't set an arrangement with me until the next year. She said she couldn't set an arrangement for this 2023 for a court date that was in 2024. So I tried to reach out to counsel about what I needed to do because I wasn't really given like a time frame in which I needed to pay it. I was just told that I could make a payment arrangement, which I definitely do need a payment arrangement on it. So I just put back, I work as a waitress, and I just put back my tips between $35 and $50 a month until,
Wait,
but-
what is this payment for? And how much
The,
is?
the offer
The
that,
court
sh-
cost.
the offer that she was given, Judge, was, she's ultimately charged with possession of controlled substance. The offer that she was given by the state was that if she paid the court costs associated, so that'd be the $515, the cost of prosecution, and the $150 PD fee, or at the very least, the cost of prosecution and the court costs. If she had paid that, the case would be dismissed. So she had been trying to do that. That's at least $615. And I thought we had taken care of it in the sense that when we announced it in court the last time she was here, we had the paperwork done to where she could go to the clerk and pay it. It sounds like she was trying to get a payment plan with the clerk, and for whatever reason, and perhaps their policies, they weren't able to set that up because she had a court date this year instead of 2023.
I'm not even sure, Your Honor, if she's allowed to do a payment plan for this kind of agreement. I think that is the problem. Now, I can suggest something, Mr. Gibbs, if she needs additional time. We can come back on the 8th. She pleads into a PTI, and then after she pays the court cost, we dismiss the case.
So Judge, yeah, let's set it for February 8th so we can get all that worked out.
All right, thank you. Okay, thank you.
Yeah, you're good to go. Give me a call. And inmates, if we're ready.
Who are these people have cases, or are they just watching, or? No, okay.
Your Honor, Tim Gibbs on behalf of Richard Abenahar. This is 22 CF 2903, 23 CF 146, and 23 CF 1544 VOP arraignment judge. We're going to enter denials across the board. We'd like to leave this set for February 8th, Judge. Speaking with the state, we had filed a sworn statement from a witness that added context to the situation under which Mr. Abenahar is charged in his new law violation. The state apparently, of course, would like time to speak to the alleged victim about the statement that was made. So we'd like to set this for February 8th so the state can satisfy the
February
Marcy's
8th.
law requirements.
How about it? Okay.
February, it's okay.
Thank you.
And then we'll see.
Okay, thank you.
Your Honor, Tim Gibbs on behalf of Deshaun Allen. This is 23 CF 1641, if I may have just one moment. Just let me grab you a pen. And today's date, which is January 25th. The 2024. Okay, you got it. If I may approach Judge, written clean score sheet.
All right, this is 23 CF 1641, State of Florida versus Deshaun Allen. Mr. Allen, would you please raise your right hand to be sworn? You swear the testimony you give for this course the truth, so help you God. Okay. Speak up, okay?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, ssir.
You want to admit that you violated probation?
Yes, sir.
Has anyone forced you or threatened you to enter this admission? Did anybody force you or threaten you?
No.
Okay. Are you aware of the rights you're waiving by entering this admission? You aware of your rights you're waiving?
The right to go to a hearing, the state prove the VOP against you.
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Speak up.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Yeah. Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Sir.
Court finds admission freely and voluntarily in. Court accepts it, revoke and terminate probation, sentence you to 60 days, Okaloosa County Jail, credit for time served, $100 VOP fee, $150 PD fee, money due within 180 days or to collections.
Thank you, Judge.
Okay, thank you.
If you feel like you're being held longer, write me into it, okay?
Is that withheld or guilty?
If it's straight jail, technically it has to be an adjudication.
Guilty. Adjudged guilty. All right, we're going to take a 17-minute.
Judge, actually, I think the jail was wanting us to let me go ahead and arraign Stephanie Medina, so you just take them all back. Oh, I thought you had, okay, I'm sorry, I misunderstood. I thought she was like at the door.
We're going to take an 18-and-a-half-minute break.
It's now.
All right, please.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formal Wear. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us.
On those charges?
I think we were at first appearances, Judge.
Okay.
So I'll just enter a plea of not guilty on her behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right. February what, 26th?
26, Judge, although I'll bring the file in with me when we bring her in next week. I think this is one we were trying to get
Work
a
it
bond
out.
hearing or something for. Let me see what I've got. No, I've got past 228 for VOPs. So, no, Judge, the 26th will be fine. We'll just have both cases come in then. If I can get it resolved earlier, I'll bring it in earlier.
Do you think, since there's a violation of probation, miscellaneous would be?
I don't have a problem with that.
Okay. That would be fine, Your Honor. The 27th?
All right, February 27th. Okay, thank you.
Thank you. Judge, that's all I have until this afternoon. May I be excused?
Yes.
Thank you, sir.
This side. Good morning, Your Honor. Tim Gibbs on behalf of Avery James Amos. This is 21 CF 966, if I could have just one moment. So again, say modify the only condition. Observe, terminate on the- These fees have to be added. Withhold, you should have all your time in, if that's still what you want to do.
So it'll be.
Otherwise it goes to collections.
When I find out my actual release date.
The jail will let you know.
All right, bet. What's today's date?
January 25th.
25th.
Very much, if I may approach, Your Honor.
Mr. Amos, would you please raise your right hand to be sworn? You swear the testimony you give for us course of truth, so help you God?
Swear.
Okay. This is State of Florida versus Avery James Amos, 21 CF 966. Mr. Some kind of. You're about to blow up over there, Mr. Ken. You need to. Okay. let's see, Mr. Amos, you want to admit that you violated probation?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing?
No, sir.
Okay. Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds submission freely and voluntarily entered. Court accepts it. Court's going to reinstate probation and modify condition, only condition to 30 days Okaloosa County Jail credit for time served. And then, what, terminate his probation?
So it'll terminate upon his release from jail, Judge, once he's satisfied those 30 days.
Okay.
And then we add the court costs that have to be assessed. We're asking for 180 days for him to pay that before it goes to collections. And then, yes, probation terminates upon his release.
All right,
That was to
$100
maintain
cost,
his withhold.
$100 cost of prosecution, 150 PD fee, money due in 180 days or to collections, adjudication withheld. So I guess, how many days you got in
He
already?
should have the credit or very close to it with the VOP, Judge,
Okay, so you'll probably be out any day now.
no later than this weekend,
And he is not going to be on probation, correct?
after he's released from jail,
From
correct?
jail, okay. And the court orders you not to break the law. Thank you.
Yes, sir.
So, I don't know if they need. Good luck. If you feel like you're being held too long, let me know. Your Honor, Tim Gibbs on behalf of Jake Coleman Bell. Judge, this is 23 CF 1927, 23 CF 2374, 23 CF 2822. If I could have just one moment, please, Judge. That, sign right there for me, please. And then today's date. If I may approach, Your Honor.
Are you Jake Coleman Bell?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
This is State of Florida versus Jake Coleman Bell, 23 CF 1927, 23 CF 2374, 23 CF 2822. You want to admit that you violated probation?
Yes, sir.
And you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea
Yes, sir.
or this admission? Has anyone forced you or threatened you to enter this admission?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. On all cases, the court will revoke and terminate, sentence you to 13.8 months Department of Corrections, credit for time served, concurrent and coterminous on all cases, all counts. $300 cost of prosecution for a total $350 PD fee. Total to collections. And the state will null pros case 24 CF 100, correct?
That is correct, Judge.
Okay, has that got it?
That covers it, Judge.
Okay, thank you.
Thank you.
Your Honor, Tim Gibbs on behalf of Chad Austin Brown. This is 23 CF 2214. You can see it right here, sir. Judge, this was initially set on today's docket for a Nelson hearing. At Mr. Brown's request, he had sent a written motion into the court. I was provided a copy. I have spoken to him a little bit since. I spoke with him this morning regarding the direction I'd like to take on his cases. If he'd still like to go forward with the Nelson hearing, we'd need to swear him in and have that hearing.
So you set depositions and everything on his case?
We'll be doing that, Judge. We'll also be having him evaluated. He's already been evaluated by Dr. McDonald and has been deemed competent by Dr. McDonald. So we'll be also looking into other evaluations that are relevant to his case through Dr. McDonald.
Sounds like they're they're working your case to have you evaluated and setting depositions and everything.
Yes, sir. My only issue was the speedy trial, and my bond should be, something should be off my bond. I can't really talk about it right now, but
we can
me and him's already cleared up our issues, I believe.
Okay.
So I'd like to forfeit the.
Withdraw that.
Withdraw the, yes, sir.
Okay, well, what's has he got a bond date set?
He does have a bond, Judge. I'm going to be meeting with him to see if we can reset him for a bond hearing, perhaps February 8th. There is an alleged victim in this case, so I know the state's going to want time
Well,
to
we'll bring
notify
it back February 8th, look at that bond, okay?
Let's go ahead and set him for that date, Judge, and I'll make sure to file a bond motion as well.
Okay, all right, this is Mr., was this Mr. Brown?
Yes, Your Honor.
Okay. All right, well, okay, sounds like they're working diligently, so let's get you back on February 8th to consider your bond, okay?
Thank you.
Thank you.
All right, thanks.
Mr. Creech.
Mr. Creech.
Your Honor, Tim Gibbs on behalf of Stephen Creech. Judge, he's initially on docket today also for a Nelson hearing in 21 CF 2333. We've also talked in the jail about his cases. He also has Judge 23 CF 87. I believe he would like to withdraw his Nelson hearing motion today as well, and he also would like to enter a plea to the bench on 23 CF 87, where he's charged with battery in the jail.
What is, I mean, we're not set for that, are we?
No, Judge, and I would ask to continue it because it's a case that involves a victim. I have to give him the opportunity to address the court.
Yeah, you got to comply with that Marcy law?
Did we use today? I'll set him for February 8th then.
Yeah.
State can give notice for the alleged victim in that case to be here.
Yeah, it's going to depend. He's currently incarcerated, the victim, Judge, so I would have to get in contact with his attorney. I think I'm going to need a little bit more time.
The victim's incarcerated?
The alleged victim is, I believe, Mr. James Terrell. He is a client, or at least was a client of Mr. Jeremy Keach in this division. Gentleman, I believe, is in a wheelchair. That is the alleged victim on the battery in the jail where Mr. Creech is charged, so we're wanting to try to resolve that as quickly as possible.
See what you can do so we can, Mr. Creech is, I think he's looking at substantial prison time already, isn't he?
So Your Honor sentenced him to 42 months back on January 4th for the failure to register case that we went to trial on.
Yeah.
So now we're trying to get the other
See
two
if we can
cases wrapped up.
Yes, Judge.
See if we can get this wrapped up.
There is an offer on the table from the state, and I've discussed that with him. He was hoping to be able to plead to the bench on the.
All right, well, we'll see. Okay, February 8th, is that enough
Yes.
time? February 8th.
We can try. Yes,
You withdraw the Nelson hearing? Nelson?
Yes, Judge.
Okay.
Are you withdrawing the Nelson
Yes,
hearing,
sir.
Mr. Creech?
Withdrawing the
All
Nelson
right,
hearing,
thank
Your
you.
Thank you,
Okay,
Judge.
thank you.
Your Honor, Tim Gibbs on behalf of Brian Crocker. This is 23 CF 626, 23 CF 2360 for VOP arraignment. Judge will enter denials across the board, but we are looking into getting him into an inpatient program for rehabilitation. He also, Judge, he has 24 CF 63. We'd like to go ahead and enter a not guilty plea, set all three cases for February 8th. We should have an answer from Keaton by then to try to get him sentenced and sent off.
All right, well, I don't have that 24 case on my docket, but.
I believe it's set for arraignment next month.
Did you want to arraign him today? Is that what you're doing?
I don't know what
On
it
the new
is.
case, if we could go ahead and just plead not guilty, or do we want to just set it off for the 8th?
It's up to you, the defense, Judge.
Or we could just move the arraignment to the 8th. That's fine with me, too.
What's the charge?
I believe it's possession of controlled substance, Judge.
Okay, well, you're pleading not guilty, ask for a jury trial. Okay, well,
And ideally, we can get it resolved on the 8th.
okay, we'll set it for
assuming he's
February
approved.
8th and point to public defender if he's not already appointed.
Thank you, Judge.
So you've been arraigned on that. He's pledged you not guilty. Bring you back February 8th, okay?
Yes, Your Honor. Thank you.
Thank you.
Hopefully, we got Your Honor, Tim Gibbs on behalf of Earl Dale. This is 23 CF 1454. Judge, we had set him for today's hearing in the hopes that I would hear from Mr. John Barnes to do a conditional release plan. Mr. Dale has an evaluation where the doctor is recommending that he be found not competent, but also that he be placed on conditional release. We are trying to get that plan worked out with John Barnes. I have not heard from him as to the status of that. All I know is that he was working on it. The only other option that we have as far as competency, Judge, is commitment, but again, the recommendation is for conditional release, so that puts a bit of a strain on that. I don't want to continue Mr. Deal anymore, but I think we have to in order to try to still get that conditional release plan in place.
You say, Ms. Leon?
I agree, Your Honor, that he needs the plan before he can be released.
All right, well, how much of a, we need to get this wound up for is Mr. Crocker, right?
This is Mr. Dale, Judge, Earl Dale.
I'm sorry, Earl Dale, yeah. Well, what time frame you want?
Our next court date is February 8th, Judge.
All right, bring him back next week, I guess, February 8th, see if we can get him helped.
Yes, I'll be in contact with Mr. Barnes to try to make that
thank you.
happen.
Thank you, sir.
Still working on it. Your Honor, Tim Gibbs on behalf of Leanna DeLonga. This is 22 CF 2215, if I could have just one moment. Best I can do is estimate today's date. If I may approach, Judge.
This is 22 CF 2215, State of Florida versus Leanna DeLonga. Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God. You want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes.
You aware the rights you're waiving by entering this admission?
Yes.
Anyone force you or threaten you to admit?
No.
Are you happy with the work Mr. Gibbs has done on your case?
Yes.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the admission freely and voluntarily entered. Court accepts it, reinstates, and modifies condition of probation to 30 days Okaloosa County Jail, credit for time served, terminate upon release, $100 cost of prosecution, $150 PD fee due within 180 days to collections, adjudication withheld. And when you get out, the court orders you not to break the law anymore.
Thank you, Judge.
Thank you.
Thank you.
Thank you.
Your Honor, Tim Gibbs on behalf of Cutter Ford. This is 22 CF 1928. Judge, Mr. Ford is present today. He unfortunately, he had missed court on the 4th. His mother generally transports him. She unfortunately is dealing with health issues and was unable to get him here on the 4th. The hearing that we had set on the 4th, Judge, was competency. I had hoped to have Dr. Sheehan, who was appointed by the Agency for Persons with Disabilities, to evaluate Mr. Ford. Dr. Sheehan has evaluated him, recommends that he be found not competent. However, she had recommended that he be committed to an inpatient setting for restoration training. I had questioned that because Mr. Ford had been out of custody for 8 months without any incidents. He had been home with his family, had not gotten in trouble or any new charges since the previous new charge in March. I wanted to have a hearing on that so that the court could hear from Dr. Sheehan, hear our concerns, and make a decision as to whether a commitment was most appropriate or conditional release was most appropriate. Now that he's in jail and now that he's here, I wanted to see how the court wanted to proceed. He's got 2 evaluations where they recommend he's not competent to proceed for the court to find him not competent. I don't know if the court wanted to have a hearing as to whether he should be committed or it should be conditional release, or if the court wanted to go ahead and have the hearing now, or if the court wanted to reset that hearing.
State side.
Your Honor, the state would adopt a recommendation of the Dr. Sheehan for inpatient to be sent to Florida State Hospital for restoration. He's charged with a burglary with a firearm. So they're serious charges.
Weren't there 2 evaluations?
So Dr. Zeman evaluated him at the end of 2022. Eventually, APD had appointed Dr. Sheehan out of Tallahassee to evaluate him. I've spoken to Dr. Sheehan, and I know and I understand why she wants to recommend commitment over conditional release, despite the fact that Mr. Ford was out of custody for 8 months before that evaluation took place. I do agree with the findings from Dr. Zeman and Dr. Sheehan that Mr. Ford is not competent to proceed based on their diagnoses and their evaluation. The only issue that I had was whether it would be conditional release versus commitment, again, because he had been out of custody without any issues for so long. If the court, like I said, I essentially am leaving this in the court's hands as far as whether the court wants to commit him or if we can potentially get him a bond and start working on conditional release.
What do you say about the conditional release?
I would object to that based on the recommendation of the psychologist, Your Honor.
What's his prior record?
Limited, Judge. This is a serious charge. He is charged with a PBL, burglary.
Oh, I'm going to have to go with a commitment. That's right. Those are punishable, possibly punishable by life, isn't it?
It is, Judge.
Yeah.
As charged, and he also faces a 10-year min as charged.
And a 10-year minimum mandatory. We got to make sure he's competent. So if he enters a plea or whatever, he knows what he's doing.
Yeah. That would be a commitment to the custody of agency for persons with disabilities. He may not necessarily go to Chattahoochee. They could put him in Lakeview.
Yeah.
They'll, of course, decide
Right.
where he goes.
We got to make sure he's competent so that he can adequately defend these charges. And even if he enters some type of deal or plea, he needs to know what he's doing. So, yeah, the court reviewed those. If it wasn't such serious charges, maybe, but we need to make sure he's restored to competency so that he can adequately defend himself and assist you or you assist him, whichever, and both. And the best possible outcome can happen for the victim and him. So we need to make sure that he's competent. So send me an order.
Thank you, Judge.
All right, thank you, sir.
Your Honor, Tim Gibbs on behalf of Ethan Green. This is 22 CF 1484, if I may have just one moment. Still what you want to do? I'll sign right there. Right here? Yes. And today's date, please. Yes, sir. Your Honor, if I may approach.
Mr. Ethan Green, would you please, you're Ethan Green?
Sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
You want to admit that you violated probation?
Sir.
You can put your hand down. Did you read and sign this admission form?
Yes, sir.
Did you wear the rights you're waiving by entering this admission?
Sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you happy with the work Mr. Gibbs has done on your case?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the admission freely and voluntarily entered. Court accepts it, reinstates. Probation extends it 6 months to complete original requirements. $100 cost of prosecution, $150 PD fee. Early termination upon completion of all requirements. Adjudication withheld. And so get these requirements done so you can get off probation.
Sir.
And the court orders you not to break the law again.
Sir.
Thank you.
Thank you, probation. Good luck.
And Your Honor, that the reinstatement will be there'll be 6 months from his original termination date of February the 3rd of 2024.
Yes, sir.
That is the intention, Judge,
Yes.
to reinstate to the original terms and conditions and then extend 6 months from his current termination date.
Yeah.
Thank you, Judge.
And Your Honor, just to keep Mr. Green from coming back, would the court be inclined to go ahead and put all of his outstanding monies to collections at termination?
That's fine, Judge.
Okay.
If not, are gonna turn around and send you a DVD saying he hadn't paid the money.
I know. Okay, we'll make it go to collections.
That's fine, Judge, thank you. Your Honor, Tim Gibbs on behalf of Mr. Amos Washington. This is 21 CF 2413. Judge, we are here for a Nelson hearing. Mr. Washington had filed a request asking for a Nelson hearing. I do know one of the concerns regarding Mr. Washington is discovery. I do have more discovery that I can give him right now. I had hoped to see him in the jail yesterday to discuss his case because I've been in contact with the prosecutor, Ms. Sandler, and trying to get this case resolved. Some new things have come up that I wanted to discuss with him. I will admit that I kind of dropped the ball. I had hoped to be able to see him last month, but wasn't able to get out to see him. But I'm happy to hear from Mr. Washington about the remainder of his
Well, he's
concerns.
giving you a bunch of discovery, and he's been negotiating with the state, and you're facing, it looks like, extremely serious charges. So what is it you're...
One of my concerns was the discovery that
Yeah.
I've been asking for.
Let me do this. I'm off. Here's the thing with this discovery. A lot of times, defense attorneys are hesitant to turn over a ton of documents to you and everything without discussing it with you, or even if they do, because other inmates in the jail can read it, and next thing you know, they're testifying against you. Okay, so that's why sometimes, especially on cases like this, defense attorneys are a little hesitant to just go over and give you discovery without having a chance to really go over it with you. It looks like you got a stack of stuff and he's working on it. So why don't you take a look at this? We'll just put this Nelson, well, I'm going to deny the Nelson at this time and give you a chance to look at that discovery and talk with Mr. Gibbs about what he's doing. And then if you feel like you still feel like he's not doing a good job, we'll bring you back another time. How about that? Is that okay? Fair? Okay?
Dave's gonna.
Because, I mean, he's got a whole stack of stuff he's got for you. He admitted that he hadn't been, he's...
I dropped the ball on that, Judge.
Yeah, well, that in and of itself is not a Nelson, that is not would not satisfy a removal because, especially with this type of case. So you can file another one if you want to, if you feel like at any time that he's not adequately, effectively representing you. But he's explained that he's been negotiating and he's got all this other discovery. And you say you had other discovery coming?
So there's also several body cams, photographs of the scene, pictures, other videos that we'll be going through, and there's also other evidence and discovery.
Try to get up there with that promptly and go over that with Mr. Washington. And you need to protect yourself too, Mr. Washington. If you feel like he's not doing an effective job, we'll have another Nelson hearing, okay? But at this time, he looks like he's doing everything promptly, especially with these kind of things. You don't want to rush into anything with this kind of second-degree murder charge, I think. So I'm going to find he's effective and deny the Nelson withdraw at this time, okay? When's his next court?
Judge, he should already be set for pretrial on the 26th
All right,
of next month.
I hope
We'll
that
make sure
you've
he's
been up
here.
there to see him and go over a lot of this stuff with him by then. Okay? Okay.
That is yours. I think that's everything, but I'm going to check when I get back.
Okay, thank you.
Mr. Washington, to keep that secure as best as you can, okay? All right, thank you. Okay, next.
I believe the only
uh,
other case that I had on this morning's docket, Judge, don't believe he's here. That was Mr. Oliver Beck. I had added him on Tuesday after I met with him. He had an offer to plead a PTI. We had set him for this morning so he could plead to that PTI and enter that program. He's not here. We're trying to get in contact with him. I'd like to just pass him until this afternoon to see if we can get him here.
All right.
And then if not, we can address the issue at that point. He otherwise is already set for February 26th.
And what about Mr. Hoover? Ms. Dudley apparently filed some motion for continuance.
Yes, sir. She called me yesterday afternoon.
Okay, so we'll set her for we'll set him for, what, February 26th? Is that when?
26 February.
Okay. All right, what else?
I think that completes my business for the morning, Judge. Oh, Mr. Joe Fernandez is set for the arraignment this afternoon. I already filed a written plea of not guilty for him, so we should not need him this
All right,
afternoon.
well, he's not guilty. All right, yeah. Anything else?
I think we are good until.
Thank y'all. No, there's no detention hearings today.
That's what we know, yes, no detention.
Not my week, so. Tillman's getting sentenced, yeah.
Okay,
Getting sentenced.
thank you.
Rise, please. Yeah, so I still need the other two, Green and Grice.